Hello, everyone. My name is Scott Warner, a partner in Husch Blackwell's Higher Education Group. Thank you so much for joining us today. This is an important topic relating to Title IX, and it's one that continues to generate a lot of questions and a lot of interest. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions at all during the webcast, please submit them using the question box. We'll try to answer the questions during the webcast today, but if we run out of time, we'll do our best to answer any questions that come up at a later time through email or otherwise. A PDF of the presentation is also available in the resources folder. This program has been approved for legal education and HR credit. To report your hours, click on the CEU icon at the bottom of the screen, and a certificate of attendance, including the course number, will also be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We value your feedback and we use it to plan future programs. If you're interested in additional training that our firm offers and are not signed up for our email announcements, please let us know and we'd be happy to add you to our list. That's all for the housekeeping items. We'd like to get started. Joining me today is Gwen Morales, another attorney in Husch Blackwell's Higher Education Group. Gwen, like me, represents various clients in administrative proceedings, state and federal court matters, and also before the U.S. Department of Education Office for Civil Rights. She litigates and advises colleges and universities on a variety of topics, including Title IX. So our topics for today are listed here. Title IX jurisdiction, is it Title IX or not? Understanding advisors' role. This is something that I know a lot of institutions are struggling with and dealing with, and it's something that we get a lot of questions about as well. Live hearings, a lot of challenges surrounding live hearings, and we'll be talking about that. Finally, we'll give a Title IX case law update. But first, before we get to that, I'd like to talk a little bit about what we might expect from the new administration under President Biden. A lot of questions about what will happen with the current Title IX regulations, and there are a variety of options that are listed here, but suffice it to say, there's no quick way for the current administration to make significant changes, although we do anticipate that there will be some changes coming. It's hard to know exactly what that will be. Most of you probably saw the article in today's Inside Higher Ed about President Biden's goals regarding Title IX. Recall that he spearheaded the It's On Us campaign while he was vice president under President Obama. He drafted the Violence Against Women Act in 1990. He seems very interested in rolling back the current regulations and reissuing the 2011 Dear Colleague letter or something similar to it. And as many of you may know, he's also appointed Catherine Lehman, who was the Assistant Education Secretary for Civil Rights in the Obama administration, as a Deputy Director for Racial Justice and Equity on President Biden's Domestic Policy Council. So we can expect that she may have some influence over what happens on the Title IX front. But as I mentioned, what exactly will happen is far from clear at this point. The current regulations have the force of law, and there doesn't appear to be any easy way to simply overturn the current regulations, given when the final Title IX rule was published and presumably sent to Congress. There are also a number of court decisions, as many of you know, I'm sure, that impact what institutions can and cannot do under Title IX. And so we all need to be mindful of the current state of the law as reflected in the case law as well. So in sum, we all need to stay tuned and see what's coming next. Our first topic, Title IX jurisdiction. Is it Title IX or not? This is a challenging issue and one that we're finding many of our clients are spending a lot of time on. We'd like to start with a poll question. To answer this question, you can just click yes or no. Our question is, have you at your institution dismissed one or more complaints for purposes of Title IX because it fell outside the scope of Title IX? So yes or no, have you been in the situation where you've had to or decided to dismiss a particular complaint because you determined that it fell outside of Title IX? Take a minute or so here to let people answer, and we'll see what the results are here in just a few minutes. Shorter than that, actually, a minute or less. If you wouldn't mind answering, though, we'd appreciate it. Okay, let's see. So a good number, more than half have had to dismiss or decided to dismiss a particular complaint because it fell outside Title IX jurisdiction. Not entirely surprising. I know we've advised a number of clients on that issue as well. So this is obviously a very important threshold issue because it will really govern whether you're proceeding under your Title IX procedures or whether perhaps you have to proceed under some other set of policies or procedures, such as the Student Code of Conduct or a disciplinary policy that applies to faculty or staff, for example. So some important questions: what exactly is being alleged? Who's alleging it? And against whom is it being alleged? Who's the complainant? Who's the respondent? That can impact whether this is something that falls within Title IX jurisdiction. When and where did the alleged conduct occur? That'll be very important in assessing whether or not it happened in the context of an educational program or activity. Do you need more information to make the assessment? I know from a lot of the questions that have come to us, we'll see a report, and based on what's written in an email or some other report, it might not be entirely clear whether it falls under Title IX or not, and oftentimes you need to get a little more information to be able to make that assessment. And who's involved in making the assessment? In our experience, it's most commonly overseen by the Title IX coordinator, but perhaps there are other people involved in making that assessment. Whoever it may be, it's important to be able to get together, convene, and make sure that these assessments and evaluations are happening in a timely manner and in a way that will be defensible if it's ever challenged down the road. And then once a determination has been made, how are you communicating that to the potential parties, and then what happens next? So lots of issues to consider there. The big one is listed here. Did the alleged conduct occur in the context of an education program or activity? Sometimes that's really easy to determine, and other times it's not. I know that this can be a really challenging issue, but it is an important one because Title IX does not apply to private conduct that occurs in a private location that isn't part of an education program or activity. Also note that the alleged victim or the potential complainant must be participating in or seeking to participate in an educational program or activity. That's pretty easy when it comes to a current student who is alleging sexual harassment or other sexual misconduct in connection with a course in a residence hall or otherwise in connection with an education program or activity. But what about former students? It gets a little bit trickier there, and it may depend in large part on how recently the student or former student was enrolled, whether that person is still trying to access job placement or other services at the institution. Do they intend to participate in alumni activities? There's some language in the preamble about this, but suffice it to say that can get to be a pretty complicated question if you're talking about someone who recently graduated from your institution or who recently left the institution. Another very important question to think about, does Title IX apply to off-campus sexual harassment? And as you see here, like most things with Title IX, the answer is it depends. So yes, if it occurs in the context of an education program or activity, and that can happen off campus in the context of a clinical experience, an internship at a third-party site, and in any number of different contexts. So the mere fact that it's not on campus isn't necessarily dispositive. The second point is one that focuses specifically on locations that are owned or controlled by an officially recognized Greek organization or other student organization. Again, that's an extension of the education program or activity. But things that happen in a purely private location that don't have any connection to an education program or activity are not covered by Title IX. So a party at a private student apartment that seems pretty clearly outside the scope of Title IX. But I could see this getting a lot more nuance, such as a party held at a faculty member's house or a number of graduate students in that faculty member's particular PhD program. Is that within Title IX? Is it not? You'd have to really take a close look at all the facts and circumstances to help make that assessment. I think most people are familiar with this rule, but we mention it here that Title IX does not apply outside the geographic boundaries of the United States. So it wouldn't apply to a study abroad program in another country, which is a point that got a lot of attention. So we wanted to mention it here. So a couple of examples of something that would be included in an education program or activity. A student claims that they were sexually assaulted at a third-party clinical site owned and operated by a hospital that doesn't have any affiliation or association with the university and isn't owned by the university. That's still part of the education program because presumably this is something that is happening in the context of a required clinical experience, and therefore it's still part of the education program or activity. If we go to another example of something that's excluded fairly clearly from an education program or activity, a student, and this is actually an example from that's one that we dealt with, a student reported being sexually assaulted by multiple other students in a private off-campus apartment. Terrible situation, unfortunate series of events outside the scope of Title IX. Of course, the institution was free and did pursue it under its non-Title IX sexual misconduct procedures. And as you all know, that's another really complicated area. If you're not going to address it under Title IX, or you can't address it under Title IX, then what policy or procedure are you going to look to address conduct that you would have a strong interest in still addressing? And here's a more complicated situation where some of it might be under Title IX and some of it might not be. Sometimes, as I'm sure you all know, there are situations where there can be a series or a host of allegations, and some of them, for example, could occur in a residence hall. Other alleged incidents might happen somewhere else, off campus, perhaps in a parking lot or some other location near campus, but not on campus. And still others might occur at a private off-campus apartment or other location. And so if you're in a situation where some allegations appear to be covered by Title IX and others don't, how are you going to address those? Some institutions have said that in a mixed case like that, they'll apply the Title IX required procedures to all allegations. Others have reserved the discretion to apply the Title IX required procedures to some allegations, but perhaps not to all. From a practical standpoint, it seems like you'd want to do what you can to try to consolidate things and streamline the process to avoid confusion and potentially inconsistent results. But you can see how challenging this can get. Another important and challenging question is whether or not the alleged conduct even meets the definitions of Title IX sexual harassment as reflected in the current Title IX regulations. And for some of these things, that can be fairly straightforward. If you have an allegation of sexual assault that involves non-consensual intercourse or something like that, then it's pretty clearly, if true, and it happened in the context of an education program or activity, then it's pretty clear that that falls under Title IX. But the issue of hostile environment sexual harassment is a bit more complicated. I'm sure you're all familiar with this definition because it's gotten a lot of attention. Severe, pervasive, and objectively offensive. In other words, it has to be all three to meet the Title IX definition of sexual harassment. This is different from the definition of hostile environment that we're used to in the Title VII or the employment context, which can be severe, pervasive, or objectively offensive. You don't need all three. And so this is another important issue to consider at the very outset, because if it doesn't meet this definition, even assuming all the allegations are true, then it doesn't fall under Title IX. It still may be addressed under a different policy, but it wouldn't fall under Title IX. And this could be really difficult to assess at the outset of a particular case. And so we try to encourage folks to not be unduly restrictive in applying this, but thinking about if everything the complainant says is true, could it meet this definition? And if the answer to that is yes, then you probably want to proceed under Title IX, but there may be situations where something simply just doesn't meet that standard. To use a couple of brief, or at least one brief example, if a faculty member makes one single reference to a student's physical appearance in class, for example, that might not be both severe and pervasive, even if it is objectively offensive. But if there are multiple references by a faculty member about the student's appearance that seem sexually motivated or romantically motivated in some way, then that would likely meet the definition of a hostile environment. So one final point here just to touch on, if it's not Title IX, some or all of it, of what's being alleged, then it's important to consider what other policies would apply or could apply and how you're going to apply them. And I think here, this is where there's a lot of potential for confusion on the part of potential parties. And so the more that you can do to clearly spell this out, not only in your written policies and procedures, but also in other communications to members of your community, and also address this in training, probably the better off you'll be. The policies and procedures, I'm sure, as you know, have gotten quite lengthy and complex, and so undoubtedly you've got good language in your policies and procedures that attempt to explain this, but I think it's also important to look for other opportunities to educate your community about these things. And before turning to advisors, we have one more poll question for you. We'd love to get your reaction to this one. And you'll see there are more choices here. But the question is, for any complaints that have been dismissed under Title IX, how has your institution resolved them? Have you investigated or resolved them through the Student Code of Conduct, investigated or resolved them through a faculty or employee handbook or other policy, applied some other policy, or have you dismissed or closed the matter with no further action? So to the extent you've dismissed things under Title IX, we'd be interested in knowing which of these options or some other option, you can click the other box, you pursued to try to address those. And again, we'll give you a little bit of time here to provide your answers, and then we'll look at the results, and then Gwen will start a discussion today about the role of advisors in the process. Okay, let's see what folks have said. Yeah, so the most common response is, not surprisingly, given the nature of these allegations, is that it looks like most institutions have then pursued the matter either under the Student Code of Conduct, presumably if it's a student respondent, or through one or more other policies that apply in some other fashion. So maybe that's an employment policy, or maybe it's something else entirely. Hard to know exactly what that would be, but as you'll see, just the large majority have understandably chosen to pursue these matters under some other process rather than just dismissing them from a Title IX perspective and then not taking any further action. So with that, we'll start to talk a bit about the role of advisors in this process.
All right, thank you, Scott. Hi, everyone. I'm Gwen Morales. Thank you so much for joining us today on a Friday afternoon of an eventful week, I'm sure. I'm going to talk about the assignment and role of advisors first. So to give you a little roadmap for what we'll be talking about, talk a little bit about the assignment of advisors, and then the role of advisors during the investigation and hearing process, questioning by advisors, and then actually I think Scott will address, when I turn it back to him, the confidentiality and other expectations in these proceedings. So we started with a basic question: do parties get assistance in the grievance process? As a reminder, they do, yes. Both parties do get assistance in the grievance process. The parties have the right to be accompanied by an advisor of their choice during the investigation and hearing process, and the institution must provide the party an advisor for the purposes of conducting questioning at the hearing if the party doesn't have one. So that part in that second or that third bullet is bolded because that's the part of the process where the regulations require that the institution provide an advisor if the party already does not have one. Otherwise, the parties are permitted to have an advisor throughout the process. And that advisor can be, it can be an employee, it can be an attorney, or it could be another third party. Equal competency between the parties' advisors is not required. And by this point, we mean that if one party has a lawyer as their advisor and the other party does not have an advisor and you're in the position of needing to appoint one, you are not required to provide that party a lawyer as well. So that doesn't necessarily mean that the student won't be disappointed or won't want one, and you may need to take into account who the advisor is for the other party if you're in a position of needing to assign an advisor. But the regulations don't require that that you assign a lawyer in general, or assign a lawyer if one party has a lawyer on the other side. Some other considerations, though, in appointing or assigning an advisor for purposes of the questioning at the hearing. So as with all roles in the Title IX process, a critical key thing to keep in mind is that the advisor cannot have a bias for or against either side. So this means actual or perceived bias. Sometimes the question comes up, does this person's role in this organization or participation in a certain event or advocacy of a certain event, liking a group, does that create bias or does that amount to bias? And as a practical suggestion, we'd recommend considering some of those questions on the front end as much as possible. It's impossible to anticipate everything, but as much as possible, having some kind of process for vetting advisors. So, trying to address what types of activity or roles or past activity might give rise to, or might be biased or might give rise to potential objections from a party about bias. You might also consider having a pool of advisors that you could draw from with the understanding that that pool is available to represent both or either complainants or respondents in the process. And that way you're prepared if a party raises an objection about an advisor's perceived bias, you have other options and other advisors to draw from. Okay. Does the institution provide a party's advisor? Did just talk about this, but it's worth emphasizing again that if the party does not have an advisor, the institution must provide one for the purpose of questioning at the hearing. So the default rule is that the party selects and brings their advisor of choice, but the institution would supply one for that purpose at the hearing. We raise this and emphasize it again because one potential wrinkle that, this is probably not going to be most cases that arise, but something that could arise is if you have an issue with an advisor during a hearing, if the advisor is behaving inappropriately or there's concerns by the party that he or she is not performing that role of cross-examining adequately, those are just flags to be aware of. You want to proceed with caution because you do need to make sure that the party has an advisor who's able to conduct cross-examination at the hearing. So, perhaps in an extreme case, that might mean needing to pause the hearing, reschedule the hearing, even bring a new advisor on board if necessary to satisfy that requirement. So we have here another poll question. We are wondering, who are you using as advisors if a party doesn't have one, if you have reached that point yet and had to assign any? So please go ahead and take a few seconds to answer this. We'll give a few seconds here. The choices are employees, third parties, or other. I guess maybe other might be attorney here. All right, let's see the results. Okay, great. It looks like the majority are, or a little more than 2/3, are appointing employees, and then about a third, or close to a third, appointing third parties or other individuals as for that advisor role. The role of an advisor during an investigation. So during the investigation, the advisor's role is to support the party throughout, help the party prepare for all meetings and interviews, be present with the party during meetings and interviews, physically present, present on a Zoom call, to assist the party in reviewing the evidence before the close of the investigation. And the point here, the overall point of this slide and the point to get across is that the role is really to support the party. The role of the advisor is really to support the party, to generally be helpful to the party through what is, we know, a very difficult and very sensitive process. The role of the advisor is not to speak for the party or present the party's position, however. So sometimes that does become an issue, or if that does become an issue and you have an advisor who's trying to take on more of that role, maybe more of like a litigation type role, you can tell the advisor that this is a matter between the institutions and the parties, and that the school is going to communicate directly with the party. You're going to need to hear directly from the party. And that applies whoever the advisor is, whether they are a lawyer or another third party. What must an advisor not do during the investigation? So advisors should not inhibit communication between the investigator and the party, should not disrupt meetings and interviews, should not argue with the investigator. The advisor does not present evidence or make a case, as I was mentioning. That's not the advisor's role. We want to hear directly from the parties and interact with the parties. So advisor is there, again, to help, to assist, but they're not there to cross the line into taking over for speaking for the party or presenting the parties, presenting for the party. What happens if the advisor breaks the rules? Well, an advisor who breaks the rules may be excluded from further participation. You likely would engage in maybe a series of warnings or counseling, or there are likely steps before full exclusion, although not necessarily, depending on the nature of the conduct at issue. But just one thing to keep in mind, that if you do have an issue with an advisor breaking the rules, you may need to pause whatever interaction is in play, whether it's an investigation, certainly if it's the hearing, and make sure that the party does have a chance to select a new advisor, or that you've have a chance to communicate to the advisor what is appropriate conduct and is not appropriate conduct. And this too may be a matter of expectations that are spelled out in a written document, in a written policy, and you would want to make sure that you're following that written policy with respect to conduct that, responding to conduct that is prohibited, and responding in the appropriate way in your policy. You also want to make sure to treat both advisors equally. So making sure that you're not tolerating conduct from one advisor that is not tolerated from the other, maybe because it's presented in a different way or something like that, but just being sensitive to treating both parties through their advisors equitably and equally. Okay, what is the role of the advisor during the hearing process. So this is similar. Again, the overall role is to be supportive, to be helpful, to help the party through the hearing. So providing personal support to the party throughout, helping the party prepare for the pre-hearing conference. We recommend making good use of one or more pre-hearing conferences and the live hearing, to be present with the party during the pre-hearing conference and the live hearing, and then, of course, as required, to conduct the live questioning of the other party and witnesses. So again, the role is supportive except for that one area where their role is active, and that is the questioning role. The standard of behavior in hearings. So is there a standard of behavior in hearings? Yes. All parties, including advisors, must act professionally, must maintain decorum, not disrupt proceedings. Those are the sort of overall themes of conduct that advisors would have to adhere to. You may have more detailed, more specific expectations regarding conduct that's spelled out in policies, and so you'd want to communicate that. We do recommend communicating that very clearly ahead of time to all participants. You want to make sure that parties and their advisors have notice of their conduct expectations, have notice of what the consequences could be of not following those expectations. And you'd want to do that through any written policy that you have, making sure folks are aware of the written policy, and or holding one or more pre-hearing conferences and addressing conduct expectations at those pre-hearing conferences. And if advisors are not following the standard, as discussed, you'll want to address it. And you'll want to address conduct from both advisors equally again.
You know, Gwen, I've been looking at the Q&A, and there are lots and lots and lots of questions. We won't be able to answer them all today, although we will do our best to answer them. But I thought I might pause just for a moment to address a couple that I'm seeing a few times. Yeah. And I think it relates to this issue of for what purpose must an institution actually provide an advisor if the party, doesn't have one. And I think I heard you saying, and it's consistent with my understanding, that the only actual requirement in the regulations in terms of the institution actually providing an advisor, if the party doesn't already have one, is really for the purpose of questioning witnesses at the hearing. So not for the investigation, not for other purposes. And I think a related question was, but I welcome your feedback on this too, if a party has an advisor, must the institution still provide a separate advisor to the same party for purposes of questioning during the hearing? And I think the answer to that is no. The bottom line is a party can have their own advisor. If they do not have an advisor, then the institution needs to provide one, at least for the purpose of questioning at the hearing. Some institutions may have a policy that calls for a different process, but the requirement of providing one is really limited to questioning at the hearing. Is that right?
Yeah, I think that's right, Scott. And I think you're saying too, if the preference and the choice is to provide the advisor for other aspects of the process as well, that would be something that they could do as well. But that's not required by the regulations, right? Go ahead, Gwen. Yeah. Oh no, just you brought up a great question about assigning somebody at the hearing if they had an advisor already. And I agree with you on that. I know you and I were talking, and this relates. We're going to get, there's a slide just a couple in about who attends a hearing, and I suppose it could be possible that you could have a party who has, maybe what they're calling an advisor for other purposes. It's a good question, because if what they really have is a support person who's not, maybe their parent, right? That is going to be at the hearing, but they don't have an advisor who's going to take on that role, maybe that is something to address, to make sure they have an advisor who can conduct that questioning.
Yeah, that'll make sense. I just thought I'd pause there, but no, let's go on ahead to questioning.
All right. Thank you for addressing those. Appreciate it. Okay, so let's talk about questioning, and this is questioning being at the live hearing. So we back up a couple of steps and say, well, what is a live hearing? The live hearing is the proceeding that's held by a hearing officer or panel. And Scott and I realized that, just to clarify here, that could be an and or, because I think this is meant to say you might have a decision maker that's a single hearing officer, you might have a decision-making panel, you might also have an individual who is a little bit more of an administrator at that hearing, who may be called a hearing officer, to not be the decision maker, but to participate in sort of running the hearing. So anyway, it's held by the hearing officer or panel, either in person or virtually, probably mostly virtually now, where both parties are, or all parties are present with their advisors at the same time. The parties and witnesses testify with contemporaneous participation, meaning nobody's submitting a pre-recorded statement. And then the parties' advisors are able to ask live questions of the other party and witnesses. And they're able to, they're not required to, they're just able to. And if it's a virtual hearing, just a tip, a couple tips that have come up just in our experience and from what we're hearing. If you are in a virtual hearing, which likely we all are, a live hearing means the participants having their cameras on. So questions have come up that we've seen in this context. Can a party turn their camera off during a live hearing, or can they be off camera? Maybe they don't want to be seen by the other party. So the answer is no. You do need to have the parties and participants on camera to have that live hearing. And we do recommend telling parties this at the start of the hearing, or ideally before, so that doesn't come as a surprise. We also, just as a general tip, recommend telling folks in advance that if it's a virtual hearing, it's their responsibility to ensure that they have adequate internet connection, that they can attend from a location that will give them privacy, that they have a good connection, and so you don't run into any of those, or you minimize those technical issues for a virtual hearing. Okay. Who attends a live hearing? So again, the hearing officer or panel, and again, you could have a hearing officer and a panel, but the decision-making body, and then potentially an administrative role. The title, this is not on here, but the Title IX coordinator may also attend. Scott and I were talking to us that makes sense to do so, especially sort of in these early days of starting off this new process. It seems like it might be helpful for the Title IX coordinator to observe and learn, and just some of these practical tips, and even what I was saying about the technical aspects of a virtual hearing. Helpful to have somebody who's observing that to be able to learn for future hearings, and also to address questions as they come up about your policy and procedures. Other necessary institutional personnel or advisors, perhaps an attorney, of course the parties and each party's advisor, witnesses as they are called to testify. We have underlined this and made this note to bring up one practical tip. We would recommend that you ask each party which witnesses they're requesting attend the hearing and submit to cross-examination ahead of time, rather than inviting all witnesses to the hearing. And the reason for this is otherwise numerous witnesses might not attend, and if that's the case, you won't be able to consider their interview statements even if the party had no intention of cross-examining that witness. So to minimize that complication, just consider confirming in advance which witnesses each party wants to cross-examine. Another practical tip, other support persons may be permitted. As I mentioned, it's possible that a party might have the person who's serving their advisor, and as long as it's consistent with your policy, perhaps even another support person who's not participating but just there for support. There's nothing in the regulations that prohibits that, but you do want to be sure that you're, as with everything, that you're being consistent with your policies and that you're treating both parties the same with regard to any requests like that. So as a last tip, when you're conducting a virtual hearing, consider asking at the start of the hearing who else is in the room, just to confirm that, because we don't always know and we only see the folks on the computer screen. And the final tip that is not on the slide, since the parties and their advisors have the right to access the evidence during the hearing, it may be helpful to have someone participating virtually who has all of the evidence on their computer and ready to share the screen with the parties if necessary. So, and that might be the Title IX coordinator or another administrator. That might be a reason to have someone in that role while the hearing panel is focused on other matters. Okay, real quickly, because I want to get back to Scott, but how does the hearing actually work? It depends on your specific policies and procedures. Required elements are included here. So you have to have this real-time evaluation of questions for relevance by the hearing officer or panel to resolve any relevancy objections. You have to have, as we've been talking about, the advisors allowed to conduct live questioning of other party and witnesses if they choose to. You have this aspect that a party or witness who refuses to submit to live questioning has to have their testimony excluded. So be aware of that. And questioning of sexual history is generally not permitted. How might the questioning of parties take place? Well, here's one possibility. Your policies, your procedures, your hearing procedures might take a different approach, but one approach is to start by allowing a party to give a narrative, follow it by questioning by the advisor for the other party, followed by questioning from the hearing officer or panel. You could easily switch those second and third steps too, to maybe try to narrow the scope of the cross-examination that might happen, and have the hearing officer or panel start in questioning the party and then follow with cross. So the point there, again, is to make sure to follow any policies you have or any procedures you have about questioning. Questioning of witnesses, same thing. Same thing in terms of following the policy, and that there may be different ways to do this. So one potential way to structure this is to have the witness first questioned by the advisor of the party who calls that witness, questioning by the other party, and then questioning by the hearing officer or panel. You could also flip those up and start with the hearing officer or panel as well, again, following the policy. Okay, and here, this is where I turn it back to Scott to pick up on more about the advisor's role in questioning.
Thanks, Gwen. And so as you can see, lots of things to consider when it comes to advisors. And the reason why we chose to focus on this, among the many topics we could have talked about today, is this really does seem like something that's very new to everyone. And I think we're all trying to get our arms around how best to handle it. And I know from looking at the questions, there's still a lot of questions, which I assure you we'll be sure to answer, even if we don't have time to get to them today. So in terms of the advisor's role in questioning, the next several items that we'll discuss kind of touch on some of the practical pointers or tips that you might work into any training that you provide for advisor. I saw one question about does training have to be provided for an advisor who's selected by a party from outside the institution, and the answer to that is no. I think when it comes to advisors who are employees of your institution or advisors that the institution is engaging itself, even if they're outsiders, lawyers or others, to serve as advisors on behalf of the institution, I think you absolutely want to train those folks, because even though it's not strictly a legal proceeding, a lot of what the advisors are asked to do in questioning witnesses is awfully close to what lawyers do in a courtroom, even though it is different. So, and I think that's reflected in the next several slides that I'll cover. So it's important for advisors to ask relevant questions. We'll talk a little bit more about what that means, including those that are typically characterized as cross-examination, that is, asking questions of the other party, asking questions of witnesses. And the idea is to try to elicit information that will help the party that the advisor is working with. Perhaps an obvious point, but this from a high level is really what the advisor's role is or goal should be in questioning. So, the types of questions that advisors should ask, again, this gets into some fairly nitty-gritty practical tips or pointers, but it's important to take a look at exactly what allegations are at issue, which policy provisions are at issue, what are the definitions of the offenses that are at issue in the hearing, and look closely at those to think about what kind of information, what facts would help support the party's position, whether it's the complainant or the respondent, when it comes to the elements of those various definitions. And as you all know from poring over these policies, the definitions themselves can be fairly complex, and they can often include multiple different elements, multiple different things that might be the subject of questions. And then really try to hone in on the most compelling points, the most important points that go to the party's position in the case. And then if there are credibility issues, such as inconsistent statements or other reasons to question one or both parties' credibility or a witness's credibility, advisors would want to ask questions about those things as well. And as you can see, despite what I said about it not being a legal proceeding, it is a complicated job. It's a tough job. And so I think particularly for those of you who are asking employees to serve as advisors, giving them resources and training is a very, very good idea to hopefully increase the comfort level that people have with what is, I'm sure, a fairly awkward position, frankly, to be in for many. So some ideas in terms of what makes questioning effective. Making the questions clear and easy to understand, not long, complicated, compound questions that have multiple parts, but really trying to make the questions as clear as possible. I've already mentioned the question should be directed at advancing or promoting the party's particular position in a case with respect to the issues that are being addressed at the hearing. Trying to think about the order of the questions to make them effective and hopefully tell a story of one sort or another, so that the testimony or the information that's being elicited is easy to follow for everyone, frankly, but most importantly for the hearing officer or the hearing panel that's going to be asked to reach a decision. And then poring over the questions before they're asked, again, just to make sure that they really are the ones that need to be asked, and that they're in the proper order, and that they're as clear as possible. It's up to the hearing officer, the hearing panel, to decide whether questions are relevant or irrelevant as the hearing goes. And there may be a question, well, what should an advisor do if a question is deemed to be irrelevant? The advisors essentially have to live with that decision, and they shouldn't be arguing with the hearing officer or the panel like a lawyer might do in court. But if there's a question or the advisor wants more information about why a question has been deemed irrelevant, that could very well be a valid point for a follow-up question. So another sort of lawyerly question: is an advisor required to make objections if a party believes that the other party's advisor is asking inappropriate questions? The party may object, but given the limited role that advisors typically play, unless your policy says otherwise, advisors really aren't the ones who are supposed to be speaking or making objections. They might whisper in the party's ear or silently advise a party to raise an objection, but it really should be the party rather who's raising the objection. So yet another, you can tell we're lawyers, is an advisor required to act like a lawyer? And the short answer is no, in the sense that an advisor role is a non-legal role. There may be advisors, of course, who are lawyers who have been retained by a particular party. That's slightly different, although even there, the role of advisors who happen to be lawyers retained as counsel is limited under the Title IX regulations, and I'm sure under your policies. So this particularly applies to advisors who are employees of the institution, as opposed to retained counsel, but they're really not acting as lawyers. They're there to support, they're there to ask questions of witnesses and the other party during the hearing, and that's really their role. And of course, they can provide support to the party that they are working with, but the idea is not for advisors to assume the role of a lawyer, to understand all of the legal rules, to act like a lawyer, to argue, etc. It's different than that, although I'm sure that sometimes those differences don't really seem so stark. But as a technical matter under the regulations, the role of an advisor is really supposed to be different from an advocate that is acting as the party's representative for all purposes. It's much more limited than that. Turning to confidentiality, just a couple of issues to touch on here before we close with some practical tips, some additional practical tips, and then a brief update on some important Title IX court decisions. Must an advisor maintain confidentiality? Yes, if an advisor is an institution's employee as opposed to an outside lawyer retained by the party, then the advisor needs to comply with confidentiality, comply with FERPA, just as any other employee does. So when it comes to sharing information outside of the institution or with others, think about it from a FERPA perspective. If a party has engaged an advisor who happens to be a lawyer and they're engaged as counsel, that person is not an institutional employee and isn't subject to FERPA. And so we all know that there's more that those folks can say, either in a lawsuit or agency complaint if the person chooses to go down that road, or otherwise. But when it comes to your own folks, either your own employees or people that the institution has engaged as contractors or consultants to serve these roles, they're subject to FERPA just like any other employee would be. So another sort of legal question, are an advisor's communications with a party privileged, like the attorney-client privilege protects communications between a lawyer and a client? And the answer is no. Again, if the advisor is an employee of the institution, there's no privilege that attaches to those communications. And in fact, there may be situations in which the advisor might have some sort of duty or obligation to disclose information, particularly if there's information suggesting that there's inappropriate conduct occurring in terms of witness tampering, or maybe the party is engaging in suicidal ideation or is talking about harming himself or herself or their self. There may be situations where the advisor really does have to come forward and make some kind of a disclosure. If the advisor is an attorney engaged by the party as a lawyer, then obviously the attorney-client privilege would apply to those communications, but not if the advisor is an employee or other agent or consultant of the institution. With that, I'll turn it back over to Gwen to wrap things up in the time that we have remaining today. I think I'm not sure if Gwen's.
I'm sorry. How many? There we go. Quick poll question. I know we've got limited time here, but how many live hearings have folks had under the current regulations? None, 1 to 5, 5 to 10, or over 10? We'll just do a couple seconds here. All right, let's see. Okay, all right. So for a lot of folks,
Wow.
they have not had a hearing yet. Yeah. Okay, so yeah, so this is all very new, and we are all learning as we're going, including from the big picture things to the nitty-gritty things about internet connection. It's all a learning process. So with that in mind, some practical tips. We've been talking about these a little bit throughout, but just to highlight those again and mention any that we neglected to mention throughout, make sure, as Scott had emphasized, to review and confirm the Title IX jurisdiction before conducting the hearing, and that you have jurisdiction or that Title IX jurisdiction applies, and then because otherwise, you may need to address or want to address under another policy. Remain open to the possibility of informal resolution, which can omit the need for these difficult hearings. Make good use, as we were saying, of one or more pre-hearing conferences where you can clarify expectations, make sure you know what witnesses are going to attend, which witnesses the parties want to attend, how it's going to work, answer questions. That will just help the hearing run so much more smoothly. Make sure just to think about these technical aspects of the virtual hearings. How are you going to make sure that people have access to the evidence during the hearing? Make sure people know they need to have reliable internet, keep their cameras on. And that with a virtual hearing, something to advise folks is that if they're sitting close together before a computer screen, just to advise the parties and their advisors that the advisor needs to be a silent advisor. So if they're advising their client, just to keep their voices low so it's not overheard. And then, yes, training is key, just to make sure. There's a lot going on in these hearings with the determination of relevancy objections and participation. So making sure that everybody's trained on these new procedures and knows how it's going to work, knows how they're going to address objections and other issues that are going to arise in real time during this live hearing. Okay, in the last 2 minutes, we'll just do a super quick case law update. Adams, we included here, it's less relevant now that the inauguration has happened. Adams applied Bostock, which is the Supreme Court case that said that Title IX's prohibition on discrimination based on sex covers discrimination based on gender identity and sexual orientation. That was a Title VII case, and Adams applied that to Title IX. So it determined this was a case of a transgender boy, who the court determined that the school's policy restricting restroom use to the restroom that corresponded with the student's sex at birth violated Title IX. Now, you may have seen, there's been a lot that's going on, but you may have seen that Biden signed an executive order on January 20th that ordered every federal agency to clarify that civil rights laws that prohibit sex discrimination also prohibit discrimination on the basis of sexual orientation and gender identity. So we can expect additional guidance from the Department of Education aligning that position with Adams. Foster is an en banc decision from the Sixth Circuit. It is not necessarily groundbreaking, but it's helpful as an en banc decision and as a case where the institution was found as a matter of law not to be deliberately indifferent with regard to its response to complaints of sexual harassment. So this is a case where it was like an executive MBA program. These were adult students, and they were traveling to weekends in LA and staying in hotels for a series of months, like 3-day weekends each month. And there were the complaints of harassment by a student on student harassment. And at each step, the university responded. Now the complainant kept engaging in conduct that the complainant kept complaining about, and the university kept adapting and kept responding. The plaintiff was arguing that the university should have done more, that they should have suspended the alleged harasser. But the Sixth Circuit said that the university did enough. It responded promptly to each escalating incident, took appropriate actions, It couldn't anticipate that the harasser would do certain things, such as flagrantly violate its orders or lie about not attending commencement. It also noted that respondents have due process rights that universities have to balance in these situations. So that's very helpful. So overall, it's helpful in that this is a case where the court found that the university did enough, was not deliberately indifferent, by continually responding and adapting to each new allegation of harassment. Doe v. Marion is a short and sweet opinion out of the Seventh Circuit that affirms summary judgment for university. It's a helpful case going forward for the proposition that summary judgment, just mere allegations or evidence of pressure based on the 2011 DCL and the 2014 FAQ documents, are not enough to create an issue of fact as to whether a particular proceeding, Title IX proceeding, was biased against a male respondent based on his gender. So it emphasized that to survive summary judgment, there has to be some evidence of gender bias with regard to the process for that particular case. So that is a helpful case for those respondent cases. Doe v. the University of the Sciences from the Third Circuit, just relevant again to these Title IX discrimination claims, especially the respondent claims. The Third Circuit adopted the test of the Seventh Circuit in assessing these claims at the motion to dismiss stage. So, and basically did away with the different categories of Title IX claims, which were such as a selective enforcement or erroneous outcome. So it adopted a simpler pleading standard, which is that just to state a claim under Title IX, the alleged facts just have to support a plausible inference that the university discriminated against the plaintiff on the basis of sex. And parties can characterize that how they want. This case is also, we've included it as a good reminder that regardless of what happens to the Title IX regulations in this administration, we do now have a body of case law to contend with that establishes certain requirements for Title IX proceedings. So that is a little different depending on what circuit you're in and depending on what state you're in, because there are state requirements as well in certain states, and also whether you're a private or a public institution. But here, interestingly, the court held that as a matter of contract, this is a private school, the university's contractual promises of fair and equitable treatment required a real, live, and adversarial hearing and the opportunity for cross-examination. So some of these requirements are now embedded in case law, regardless of what happens with the regulations and with the OCR. Karasek is our final case. And this is a few months old now, but we raise it just because it addresses the idea of this pre-assault deliberate indifference claim. So here the Ninth Circuit affirmed the dismissals of the 3 plaintiffs' individual claims, but reversed the dismissal of the pre-assault deliberate indifference claims. And that pre-assault claim is a theory that the Title IX policies that the school had in place were inadequate and that created a heightened risk of sexual misconduct, which led to the complainants to be sexually harassed or assaulted. So we include that not to scare you, but just to note that this is a case that just emphasizes the importance of making sure you do have effective policies and procedures in place to respond to sexual harassment complaints as they arise. All right, I took 4 more minutes of your time. So Scott, do you have any final comments?
No, I think we can close it out, and sorry for going over, folks, but a lot to cover.
So thank you so much for joining us today. We hope the information was helpful to you and your organization. Just as a reminder, this program has been approved for legal education and HR credit. To report your hours, please click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow. Be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you.